Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and we're going to continue and almost complete our study of shareholder litigation. In our last episode, we wrapped up the resolution phase with the idea of trials, which are rare, settlements, which are more frequent, and ADR, which is growing in popularity. We talked about where most shareholder suits actually end up. Today, we're looking at some emerging trends, and we're going to talk about the future of shareholder litigation, digital tools, regulatory shifts, and how to adapt strategically. These changes are shaking up the game, making it easier to uncover problems when managers stray from shareholder interests. I'll try to keep things lively with some real world examples and tie it back to reducing agency costs, which is a core theme for this entire course. And we can do that through better accountability. So I think this is where the future of litigation gets exciting. And let's kick it off with the digital transformation that is revolutionizing evidence handling. So, first up, AI. If you haven't heard of artificial intelligence, you live under a rock. Gone are the days of lawyers sifting through endless paper stacks because artificial intelligence tools use natural language processing to scan massive databases in hours or even minutes. They can spot patterns which can signify ignored risk in emails or documents and flag them. Imagine, instead of going to a warehouse in Kentucky and spending months going through moldy pieces of paper and boxes, you could sit at your desk and say to your computer, "Show me all mentions of cyber threats the board knew about," and in 5 minutes get a curated list. That's the promise of AI in action. But it isn't magic. You still need human review to catch nuances, and courts insist on accuracy to ensure fairness. But it is a way to find a needle in a haystack with a magnet. In a securities fraud, artificial intelligence could flag discrepancies in financial reports, could prove misleading statements, have showed material change in behavior by looking at huge patterns in terms of stock prices, and could help principals hold agents accountable faster. It all potentially speeds up the process, and it could theoretically cut costs and make it harder for managers to misbehave, which might stop them from misbehaving in the first place because they know they're going to get caught. On the other hand, AI is a new and unproven technology, and it makes mistakes, it makes hallucinations. So it's a really interesting area of AI and discovery for people to delve into and try to solve some of the ethical problems that result from it. Blockchain is another powerhouse emerging in litigation. Think of it as an unbreakable, shared, decentralized digital ledger. I know that's a lot to think about. But that ledger you have, that literal piece of paper that says debits and credits, imagine if that existed everywhere all at once and everyone agreed it was true. Every entry is chained to the last, so tampering one breaks everything. For shareholder suits, it could prove timeliness. It could prove exactly the moment, the timestamp moment when a board learned of a breach but did nothing. Delaware supports blockchain for corporate records, has since 2017, and it's gaining traction elsewhere. In a derivative action over oversight failure, blockchain stamped minutes could show that no discussions happened, or it could show that they happened briefly or extensively. These are all solid evidence of duty breach or of care. This tool could level the playing field by reducing information asymmetry because these are auditable records, and that could also drive down agency costs. Agents can't fudge dates if the record's immutable, and so they may be less likely to commit the wrongdoing in the first place because they know they're going to get caught. Now, once again, blockchain is not exactly a cure-all. There actually are ways to hack blockchain. I don't have time to get into all of them here, but blockchain is not actually unbreakable, and there are different kinds of blockchains. So there's a lot to discover here in terms of whether blockchain is a solution or yet another problem when it comes to shareholder litigation. And regulatory shifts are adding new layers to these trends. The SEC's cybersecurity disclosure rules, effective late 2023, require companies to report material hacks within 4 business days. Material, that's kind of like reasonable. It means that it could sway investor decisions, either financially or by eroding trust, but we don't know exactly what that level is. Sometimes we have to figure it out later through litigation. But if you delay and you don't report, boom, suits follow. And we've seen a surge in enforcement action where slow reporting led to legal charges. So this forces boards to act swiftly, which might be a good thing. But disclosing that there has been a cybersecurity hack is also potentially harmful to the company. And disclosing potential hacks that didn't really exist because the managers are nervous about the risks is actually problematic. So there's complexity here too. And on the global front, the European Union Digital Services Act exerts pressure on U.S. firms with its extraterritorial claims. EU says that it can actually reach in and demand greater transparency in data handling and platform operations of U.S. companies. Fail to comply, and now there's cross-border claims that it could expose you to international agency issues. And suddenly you have to hire an international law firm to deal with a case in the European Union. These shifts are reshaping market dynamics and legal strategies. On the one hand, cyber related claims are surging, but interestingly, insurance premiums are stabilizing. And what seems to be happening is companies are themselves adopting AI driven compliance dashboards to spot risks early. And the implementation of these dashboards can help demonstrate due care, reducing the likelihood that a suit will proceed even if some issue slips through. To adapt, you could integrate digital tools into your playbook. So now we have AI in discovery and also AI in compliance, which can also be used to either build a stronger case against misconduct or to show that there was due care and no misconduct. And the blockchain could prove unassailable facts, and whether that helps shareholders or directors depends on what they do. There just might be more evidence to be found. Strategically, forums like Delaware have governance expertise in derivative suits. And so parties still choose to incorporate in Delaware and litigate there because they continue to be on the leading edge of understanding these issues. Of course, you might go to federal court for a securities heavy direct action because you might want to file that under the Securities Exchange Act of 1934, which gives you access, of course, to the federal court system. And right now, everyone should be monitoring global regulations and trying to harmonize practices to avoid pitfalls where the European Union is going to reach in with extraterritorial claims that your company isn't prepared to address. So, this evolution is making shareholder litigation really complex. There's a lot more data out there to deal with as well. And so, shareholder litigators are really trying to figure out this new landscape, and it's really quite fascinating. I'll try to bring this to life with one hypothetical. Suppose a company suffers a hack but delays reporting beyond 4 days. This would violate SEC rules if the hack was material. So, in a direct suit, AI could scan internal emails and show whether or not there was scienter, whether or not the directors knew that there was a material adverse event. That would prove a misleading omission, and that would help it survive a motion to dismiss. That would make it potentially plausible, potentially efficient, and affordable for shareholders using their rights to information to make the kind of pretrial motion that will survive a motion to dismiss. And AI could potentially do that. But on the flip side, we could have an AI dashboard which is looking for cybersecurity threats and reporting them when they occur. And if that's in place, that might actually show that there is reasonable care, showing that if the AI determined this was not a material event, that might be evidence that the directors are not liable. So we have some complexity there as well. Challenges are real. So let's break them down with some examples to see how they play out. First, let's talk about the cost. Discovery can eat up at least half of litigation expenses. Lawyers bill a ton of time doing document review. One solution is to use AI to cut down time, but you still have to pay for the AI solution. It's not like they come for free, and good ones are quite expensive. Plus, you need to have attorney oversight because you can't just say the AI ate my document and as a result, I'm not responsible. So you need to budget carefully and use these thoughtfully. For instance, in a direct suit over false earnings where you're chasing thousands or millions of internal emails, those hours can really add up fast, and AI could slash the bill by flagging key ones early. So it can be really useful as a tool, especially in early stages of discovering whether or not a case is worth pursuing, and you have a ton of information to go through. But again, it's not always something you can rely on. The technology isn't quite there yet. And one thing is for sure, if the AI messes up, you can't hide behind that and claim not to be responsible because the AI ate my homework. Second, objections often come up like claims of privileged information, and it's crucial to hold back privileged information, but not to overhold back information. So when you protect information from lawyer-client talks, you also can use artificial intelligence to try to determine what information should be held back. But you also need to be responsible for not unduly holding back information. And you may not be able to claw back information that an AI released because it didn't perceive it as potentially privileged. So there are all kinds of issues with using AI to try to limit the cost of shareholder litigation. Again, the discovery being the most important cost, the highest cost, and oftentimes where cases proceed until they're settled, this is where we're all trying to focus on reducing waste. But it can be very, very difficult to do this. A third that I'll mention here that I brought up earlier in the season is that courts can also limit requests to protect trade secrets. And then you can get a protective order so that the entire case or part of the case proceeds under seal. That complicates things even further. So if a discovery request is for internal audits showing real numbers, there could be an objection that that is proprietary business secret information. So you would have to argue as a plaintiff that it's needed to prove that there is a material misrepresentation. The judge can say you can have it, but it's sealed. Now, can you take sealed information and plug it into artificial intelligence? And what happens if by doing so, the trade secret gets out? Suddenly you've got a misappropriation case. So again, lots of interesting complexity at the intersection here with emerging trends like artificial intelligence, blockchain, new regulation, trade secrets, all making shareholder litigation more complex than ever. I hope that excites you because if this is a field you want to go into, it's clearly blowing up. It's clearly an exciting field. And we've only scratched the surface with this podcast series, which we are going to conclude in our next episode. So hang on for that one last episode. And until then, I'm Professor Seth C. Oranburg, and this has been Organized.